In this insider-exclusive network TV special, Justice in America, Shelton Stewart's story, we visit with Bob Genis, founder of the Sonin Genis law firm, to see how he successfully won an $8 million verdict for his client, Shelton Stewart, who was severely injured when he slipped and fell due to pigeon droppings on the exterior steps leading from a New York elevated train platform down to the street below. He sustained a contusion to his cervical spine, requiring a laminectomy and fusion. Bob has earned a reputation for an unyielding trial lawyer who repeatedly represents individuals and families against big companies and the Goliaths of the world, and he repeatedly wins. He has earned the highest respect from citizens and lawyers alike as one of the best trial lawyers in New York. He's built a substantial reputation by consistently winning cases other law firms have turned down. And his amazing courtroom skills and headline-grabbing success rate continue to provide his clients with the results they need and the results they deserve. This is the Insider Exclusive, live from New York. It is my great pleasure to introduce Bob Genis to the show. Welcome to the show, Bob.
Thank you, Steve.
Tell our audience a little bit about your firm. What type of law does your law firm practice?
Our firm practices Sonin and Genis. Our office is in the Bronx, but we've tried cases in 7 states. We do plaintiffs' personal injury medical malpractice. We represent the families of people that have been killed or seriously injured by the negligence of others. We've been doing this since 1988. I've been doing it since 1983, and we're considered a pretty good firm. We work real hard.
Now, in your spare time, I understand you're active within New York State Bar, right? You teach classes. Tell our audience a little bit about that.
Sure. I teach a lot, mainly with the New York State Trial Lawyers Institute, New York State Trial Lawyers Association, where I'm an emeritus director. I've been their director for over 21 years. I'm in charge of the New York State Trial Lawyers Institute program on evidence. It's called Evidence to Win. We do that all over New York State. I also co-chair Depositions to Win. I teach a lot of different classes for them and many other different bar associations throughout the state and the country. I've taught on a national level for AAJ, American Association for Justice. I've taught at the Masters in Atlanta with Don Keenan. I've taught all over the country.
Right, and lawyers really need to go to some of these seminars, if you will, in continuing education, because you don't learn this in law school, do you?
Absolutely. You don't learn any of these skills in law school about how to try a case, and that's what we like to teach, and the law of how to try a case.
Bob, we're here today to discuss another very interesting case of yours, Shelton Stewart. And before you tell about the facts, let me just say this, and this is going to keep our audience interested. To my knowledge, and maybe yours, this is the only case in New York that was found in favor of the injured party with the set of circumstances that you're going to tell us right now.
That is true. And what happened was, it is a set of circumstances where a man slipped and fell on a stairway at an above-ground outdoor subway station. It's a train station. Subways are trains. And pigeons were living and roosting in the station.
As they do.
And the transit authority knew this and did nothing to get rid of the pigeons. And then pigeons do what pigeons do, is they poop. And they poop all over. And pigeons have spots that they like. So this was a recurring condition where every day the pigeons would be making on these steps that the commuters, the people that use the subway, need to walk on to get on and off the train to get work and to get home. So they knew the pigeons were there. They did nothing to get rid of them. And then they didn't clean up the poop, knowing that there's unsafe recurring conditions there. So my client, he's coming home from work, and he's coming down the steps, and he stepped on the pigeon poop that was old, had been there for over a day, because he actually saw it the day before when he went to work in the same spot. Forgot, you're allowed to forget, you're not a computer. And he stepped on it, and that's how he fell and became badly injured.
So let's talk about that badly injured. His injuries were severe, weren't they?
They were very severe, but that was another issue of controversy. The transit authority, this was a case against the transit authority, felt that his injuries were not causally related, because we never disputed or denied that before this ever happened, he did have neck injuries. He did have neck conditions that needed surgery before this ever happened. However, this made it far worse. This caused what's called a contusion to the spinal cord itself, which was a very serious and traumatically induced injury, separate and apart from what he had. And he required multiple surgeries. He had complete fusion hardware fusing his neck, so he can't really move his neck. Similarly to his low back. And in fact, his pain was so severe that after he had the spinal surgeries for hardware, neck, and back, he had to have what's called a pain pump, literally surgically implanted into his body to give him pain medication. And these pain pumps have to get replaced every 5 years.
So you have to have more surgery.
Correct.
So in this particular case, it seems to me, in a lot of your cases, it is the battle of the witnesses. And I would only assume that some of the medical experts that you bring into court for these cases, they cost a lot of money, don't they?
They do.
Yeah, because, and then depending on their credentials, like we recently saw in the George Floyd case, they had, for example, that Dr. Tobin, that was on there, good Irish guy, I like to say, but anyway, the pulmonary expert, right? You get real detailed. And so really it's up to the jury to determine who's more factual, who is being spot on, et cetera, isn't it?
Yes. And I think the key to that is the mastery of the medicine. We will know medicine better than any doctor because I will cross-examine their doctor and prove my case through their doctor, which is what I did in that case, as I do in every case. I will have a medical library that's I don't want to say second to none, but I have a great medical library. I will know my medicine. We have models. I will have anatomical models to show the jury. We do posters so that they can visualize, see what's involved in this injury. They could see on the MRI, a big poster of it, here's the contusion to the cord. It's clear as day. You could see it. Here's the surgery, what it looks like. Here's what's involved in the surgery. So we do posters that are demonstrative. I have a certified medical illustrator do our posters. They're absolutely accurate and authentic and admissible into court. So we really leave no stone unturned. We work very, very hard to prove to the jury factually why we're right on the medicine and on the facts.
Okay, let's talk about the responsibility of the transit authority to make sure that it is a safe environment for all the people that travel on their, transportation. What was the requirement? You mentioned to me that this pigeon dropping was there like the day before, had been there for a day, whatever. What is the requirement of the transit authority to clean and make sure it's safe? Is that a 24/7 job or what?
Well, what the transit employees that we questioned admitted was that 3 shifts in a day for all 24 hours in a day. New York City subways never closed down, at least other than during the pandemic. And so when you operate 24/7, you have to be safe 24/7. And they admitted that at least twice a day minimum, if not more, they're supposed to do an inspection 3 times a day, see if there's any potentially unsafe conditions, and fix them. They're supposed to clean the stations every day, not just once a day, but throughout the day because they're being used throughout the day.
How can they prove that they did that? I hear you saying they're supposed to. How do you prove that they did that? And by the way, there's CCTV all over the place, isn't there?
Well, they have the cameras, which never seem to work unless the videos would be good for them. So we get that on the man under cases all the time. So where you want the video of what happened when the train runs over somebody. But so A, does the station have the camera? B, was it working? And was it on, etc. But then you get into they have cleaning schedules. And did they do their work? Did they fill out their paperwork to show that, yeah, I was here, and yeah, I cleaned it, and here's what I did? But what the transit will sometimes do is they have very hardworking people. They have great people that work for the transit authority, but sometimes they overwork them. So if you are responsible to cover God knows how many stations in your one shift, if you're only given 3 minutes to clean an entire station, I'm making up the 3 minutes, but if they're not giving you enough time to do your job properly, well, then you can't do your job properly, and that's the system failure. And, sometimes they're doing cost-cutting measures to have fewer employees. And these men and women, let them have their jobs, let them give them a fair opportunity to do the job so they can do it properly, so that we could have safe, clean stations. And they should be held accountable to have safe, clean stations.
What was the end result of this case?
The jury allowed him to be compensated with $8 million. The Transit Authority took an appeal on the case. It was reduced to about $6 million by the appellate court. We had literally 3 different appeals on that case, but finally, after a long, hard battle over many, many years, they paid my client, and I'm happy to say that he got his money.
And when they paid your client, they're paying interest on the money that they didn't pay at the time of the verdict, correct?
They are paying interest, but the Transit Authority, just like New York City Health and Hospital Corporation, actually pays a lesser amount of interest than everyone else.
And that's mandated by law?
Yes.
That's crazy. What is the interest rate other than the exempted parties?
In New York, other than the exempted parties, is 9%. For them, it's only 3%, which is why they also take the appeals, because it doesn't really cost them anything, so what's their downside? Now, some states like New Jersey allow prejudgment interest. So if the case has been dragging on for years, but now you win, you get interest for all of those years. So maybe the defendants don't want to drag it out as long.
Yeah, and let me just say this for all our viewers. This is not about a game of getting as much money as you possibly can. It's about the unfair tactics that are used, like with the exempted parties in this case, where they only have to pay 3% versus 9%. But the reason that they have 9% or something higher than that is because it's an incentive to pay the claim, right, rather than dragging it out, correct?
Well, you don't want it dragged out, and really, think about it. You're injured, so you've had a loss. If you had any other kind of loss and it took place over a period of time, okay, wouldn't you be able to get interest on that? Right? You put money in the bank. You have a mortgage, right? They're getting interest on that because you have the use of their money for all those years. They're getting the use of your money because it's your money that you should be compensated with. And they're holding on to that, and they're making money from it. So if they're collecting 9% interest, 10%, 20% interest, but they only have to pay you 3%, what's their incentive to pay you?
I've always wanted to ask a lawyer this question, so I'm going to tell you this. Right now, interest rates are very low. Why do they have these extraordinarily high interest rates on cases that are on appeal? Because maybe the prime is, 0 or 1% or something. Why is that rate still maintained?
Well, the rate came about when inflation, I remember, look, Steve, we're about the same age. I remember back years ago when inflation was, 20, 30%? I mean, we had an astronomical inflation rate. And that's when they increased in New York the interest rate to 9%. It wasn't always 9%.
And it's never changed.
But you don't know. What if we have inflation again?
Congratulations on this unusual case. And as we mentioned in the beginning of the case, this is probably the only case where the city had to pay, correct?
It's the only case in New York where somebody slipped and fell on poop and was able to recover.
What about private parties? Have private parties been sued? I mean, they own their property, right? Pigeons roost off their buildings and, pigeon droppings end up down below.
It's funny. I'm in the city of New York where we've got pigeons all over the place. I've never seen another case, and I'm doing this for a while, where the building didn't clean their sidewalks as they're required to by law. So if you clean your sidewalks like you're supposed to, we don't have the pigeon poop. If the transit did their job like a private owner, and they do own these stations, they are a property owner, they are the landlord, so to speak, then this doesn't happen.
I want to thank you for being on the show.
Thank you for having me.
Thanks for joining us. You can get more information about our guest and the issues at insiderexclusive.com.